ሰላም ሰላም ውድ የኢትዮጵያ ስኩል ኦፍ ላው ቲዩብ ቤተሰቦቻችን እንደምንቆያችሁልን ዛሬ በክሪሚናል ፕሮሲጀር ክፍል 1 ተገናኝተናል። እስከ ክላሱ መጨረሻ ድረስ አብራችሁን ቆዩ።
Then investigation by the police, okay, prosecution by the public prosecutor, trial by the judiciary. Okay, from the moment of commission of an offense till the trial, even post-trial, appeal, we will consider that. All right? So, the introductory matters. Okay, you will have the course outline, okay, the duplication office. I will tell, consider introductory concepts. Like definition and initial development of criminal procedure, source of criminal procedure, models of criminal justice system, due process and the crime control model, structure, purpose and fundamental principles of modern criminal procedure, and history of criminal procedure. We don't waste too much time on these issues. Anyhow, chapter 1 gives you general highlight on what the law of criminal procedure is. Then under chapter 2, we will consider setting justice in motion. How the justice process, the criminal proceeding process starts. How it starts. Okay? So in any criminal justice system or the criminal procedure, with the complaint, setting justice in motion means how the criminal proceeding system starts. Okay? So, criminal justice system or criminal proceedings generally starts by complaint or accusation. Okay? Complaint or accusation is nothing but it is an application to the police authority. Whenever you observe the commission of an offense, what are you going to do? Like, for example, you observe that a certain person is bleeding outside. The first thing that you do is to assist that person, isn't it? So that he has to be taken to hospital or clinic, isn't it? Then you also want to know who inflicted damage, who inflicted harm on that person. Because that person has been beaten by another person, he has been stabbed by hooligans or somebody else. Okay? So you want justice to be served on that person. Who injured that person? Then you will report to the police. Okay? Then police will receive information from you. Then whenever you report to the police, it is called accusation. Criminal justice system starts with accusation. Okay? So accusation is reporting the commission of an offense to the police. So we will see, is reporting to the police about the commission of an offense. I know, is it mandatory? Is it an obligation? What if, for example, you took your friend to the clinic and you said, it's none of my business. I don't worry about who stabbed or who wounded, who inflicted harm on my friend. I don't worry about it. Let him first survive. And what if you ignore it? Is it possible? Is reporting or is accusation an obligation? Okay, we will see that. So whatever it is, once if accusation to the police is made, then it is at that point on time when the criminal justice system starts. It is at that moment that justice is set in motion. Okay? So in chapter 1, we will see how justice is set in motion. Complaint, accusation in flagrant offenses, summons and arrests, these are the procedures. Okay? After an accusation is made, then police will do relevant activities for investigation. Police, after receiving information, investigates into the commission of an offense. Who committed that offense? Who have witnessed that offense? Okay? What materials, what implements were used in the commission of that offense? What is the degree of harm sustained by that person? Okay? Was the commission of an offense intentional or negligence? Circumstantial evidence, everything the police will gather. That process is known as investigation. So we will see how investigation is carried out, how police investigation is carried out. After the police receiving the information about the commission of an offense, or after an accusation to the police is made, as I said, police will gather information about the commission of an offense. Police will gather information about the commission of an offense, and after finalizing everything, after gathering evidence, whenever police finalizes investigation, then the compiled information, the compiled investigation reports will be forwarded to the public prosecutor. So after graduation, if you become a public prosecutor, then you will work in collaboration with the police. So a public prosecutor's task is prosecuting. Prosecuting. Then public prosecutor will receive the investigation report from the police. Then after receiving that information, the public prosecutor will see the investigation report. He is a professional. Okay? Then, after considering that investigation report that the public prosecutor received from the police, the public prosecutor may order further investigation. The public prosecutor may say, no, the information gathered by the police is not sufficient. These points should be clarified. Okay? As a public prosecutor, you do have this power. You can say, for example, the police investigation report doesn't indicate whether the crime is committed intentionally or negligently. The time when the offense was committed is not indicated in the investigation report. And other information. So if the public prosecutor considers that the police investigation report has problems or has defects, has shortcomings, or is not complete, then the public prosecutor has the power to order further investigation. So the public prosecutor further investigation should be carried out, and the public prosecutor will order the police. Or the public prosecutor, after receiving the investigation report, may decide not to prosecute. Okay? The investigation is complete. Whenever the public prosecutor considers it, the investigation report is complete. But the public prosecutor may still decide not to prosecute, not to file a charge. Why? There are grounds. We will see that in detail. There are some grounds. Whenever those grounds exist, even though the investigation report is complete, the public prosecutor may decide not to prosecute. Or the public prosecutor may decide to prosecute. The public prosecutor, on considering the police investigation report, may say, oh, this is complete, everything is complete, then I have to prosecute. The public prosecutor may decide to prosecute. Or the public prosecutor may order preliminary inquiry to be carried out. Preliminary inquiry. It is not a trial. It is not framing of charge in prosecution. It is not prosecution. But it is a means of recording of evidence. In the recent cases, you might have heard about it. Okay? There is what we call preliminary inquiry procedure. It is a process of recording of evidence. It is nothing but it is a process of recording of evidence. The public prosecutor will order the witnesses to appear, and those witnesses will testify to the court. The court will record that. Then that is what we call preliminary inquiry. We will consider it in detail. It is not prosecution. It is different from prosecution. Then after preliminary inquiry, then prosecution will follow. Prosecution will follow. So the public prosecutor has these powers. So if you are a public prosecutor, if you become a public prosecutor after graduation, then you will have these powers. You will have these powers. After receiving the police investigation report, you can order further investigation to be carried out, or you may decide not to prosecute because you are professional and you know the grounds. If some grounds exist, then you may decide not to prosecute, or you may decide to prosecute, and finally you may decide preliminary inquiry to be carried out. Then, assume that the public prosecutor decided to prosecute. The public prosecutor decided to prosecute. Then, what will come? Charge. Charge will come into picture. You have to frame the charge. If you are a public prosecutor, you have to frame a charge. Okay? You prepare a charge. Then you will file to the court having jurisdiction. You will file to the court having jurisdiction. Okay? Then the question is, how is charge framed? Charge will be framed. How is charge framed? How is charge framed? Okay? So there are some technical sufficiencies. There are some technical sufficiencies of charge. Technical requirements of a charge. Okay? Those technical elements of a charge should be fulfilled. So we will see, under chapter 4, we will see how charge is framed. How charge is framed. What components should be included in the charge? What elements, okay, should be included in the charge? We will see that. After framing a charge, you have to file the charge to the court having jurisdiction. Then you will file to the court having jurisdiction. Then the next question that comes is, which court has jurisdiction? To which court should I file the charge as a public prosecutor? Okay? So you should have knowledge about jurisdiction of courts. Jurisdiction of courts. So under chapter 5, we will consider in detail how criminal jurisdiction, okay, how criminal jurisdiction is organized in the criminal justice system of Ethiopia. Okay. Then, as you know, of course, you are taking civil procedure, isn't it? I don't know if you have knowledge about this judicial jurisdiction, material jurisdiction, and local jurisdiction. So, general jurisdiction is classified into three: judicial jurisdiction, material jurisdiction, and local jurisdiction. We will see these elements under chapter 5. So after determining which court has jurisdiction, then you will file the charge to the court having jurisdiction, and the trial will continue. Then what will happen at the trial stage? What are the key proceedings at the trial stage? We will see that. We will see that. So the accused has rights at the trial stage. The court is bound to observe the rights of the accused person. There are what we call fair trial rights of accused persons. We will briefly consider that, and we will see the proceeding involved at the trial stage. The proceeding involved at the trial stage, like preliminary objection, like the plea process, and examination of witnesses. There's what we call examination in chief, cross-examination, re-examination. All these processes happen at the trial stage. Okay? So evidence will be presented by both parties. Evidence will be presented by both parties, and examinations will take place. Then, after receiving the evidence, then the court will weigh evidence. Then you know the degree of proof in the criminal proceedings. Even though there is no clear procedure, clear provision, in practice, it is widely held that beyond reasonable doubt, the degree of proof beyond reasonable doubt is expected from the public prosecutor. The public prosecutor has to prove the case beyond reasonable doubt. So after weighing the evidence, the court will finally pass its judgment. So this will be the overall proceedings involved in criminal procedure law. The overall proceeding from the moment of accusation till the trial stage. So then, after considering this, we will see some related but very important concepts, like special procedures leading to judgment. Okay, this is the general. What I have my foregoing discussion was about the general criminal procedure. In respect of some specific group of peoples, like young persons, okay, there is special proceeding. So we will consider that. There are special procedures in some cases, like because the accused person involved is a juvenile or a person below the age of 18. In such cases, the criminal procedure has provided a special procedure. Okay? Then there is also what we call private prosecution. Sometimes private individuals are allowed to institute proceedings. In ordinary cases, what you know is it is the police and public prosecutors that are involved in the criminal proceeding. Police investigates and public prosecutor receives that investigation report, and the proceeding will continue. That's what we know. But in some cases, private prosecution is allowed in the criminal procedure court. Private prosecution. We private individuals can sometimes institute criminal proceedings. This is a special procedure we will briefly consider. And default proceeding. This is a proceeding in which the defendant is not found. So the trial proceeding will continue in the absence of the defendant, in the absence of the accused. The accused is not found. Even though the accused is not found, the trial will continue. That's what we call default proceedings. So default proceeding has its own rules. We will consider that. It is not in all cases that default proceeding or trial in absentia will continue. It is not in all cases. It is only in very exceptional, serious cases that the trial will continue in the absence of the accused person. Like, for example, in our case, there are top officials of the prior regime, the Derg regime, whose case continued in their absence. Isn't it? Even after the Derg regime, some politicians were in Europe or in US, but their case continued in their absence. That's what we call default proceeding. So there are conditions that should be fulfilled. Whenever the specific requirements are fulfilled, that default proceeding will take place. Summary proceedings, petty offense, and contempt. There are some summary proceedings that the trial process will immediately take place. Okay? That is also special proceeding. Proceedings in respect of petty offenses and contempt court. We will consider that very briefly. And juvenile procedures, whenever the accused is below the age of 18, then there is a special procedure. Particularly in the Ethiopian case, between 9 and 15. Anti-corruption cases regarding corruption are, carried out following special procedures. Okay? We will consider that. And finally, in chapter 8, we will consider post-judgment proceedings. After the trial is concluded, there are post-judgment proceedings. Review of judgment by the court of rendition. Is it possible in the Ethiopian criminal justice system to consider? After the trial is carried out, the trial has been concluded, then there is what we call review of judgment. We will see how it is treated in Ethiopia. Right of appeal in court of the appellate court. The appeal process after the trial is carried out, then appeal will continue. Very briefly, we will consider provisions of the criminal procedure on appeal. So this will be the overall course. This will be the subject matters of the course of criminal procedure. Regarding reference materials, I cannot assure you that all these materials, all those listed, this exists. But there is a teaching material. There are teaching materials which are mandatory. Okay, you will find. I hope it is available in the library or in the store. I don't know, but it's the teaching material. Wonderson Demse, written by Wonderson Demse, and it's a very comprehensive anyway. And there is also another material. But I suggest first you have to read Wonderson Demse's teaching material. That's very important. And also there is also teaching material. I don't know who wrote it, but it is also available in the store. But Wonderson Demse I think library and listening. Then I will be set to Wonderson Demse listening. So I'm going to Wonderson Demse. That's very important. I recommend that. Material written by Semina Kiros. I don't know whether it is in accordance, in keeping with the copyright law. So you are set to you want to Google Live upload it. So you have to listening. You have been learned about. You have learned about what procedural laws are, what substantive laws are, isn't it? So the name indicates criminal procedural law is procedural law. It deals with procedural law. Procedural law. It's all about procedural issues, procedural matters. Procedural matters. Okay. So it is a branch of law that helps us to enforce our substantive rights. It is a branch, criminal procedural law is a branch of public law. It's a branch of public law actually that helps us to enforce our substantive rights. Our substantive rights. You have, for example, the right to life. You know about human rights guarantees. The Constitution of the Federal Democratic Republic of Ethiopia, under Chapter 3, has granted a bulk of human rights. We do have the right to life, the right to liberty, the right to freedom of movement, okay, the right to security, and a number of rights. That these rights are substantive rights. These rights are substantive rights. But substantive rights will not have meaning unless they are enforced. You need a mechanism of enforcing these rights whenever they are violated. Okay? You don't have the right to liberty. You don't have the right to privacy. What if somebody contravenes your right to life? What if somebody contravenes your right to liberty? What if somebody contravenes your right to privacy? Then you should have a mechanism of enforcing those rights. Okay? So somebody, for example, contravened your right to liberty. Police, for example, come in without following the due process guarantees. Without following the due process guarantees, he arrested you, for example. Then it is obviously a violation of your right to privacy. It is a violation of your right to liberty. It is a violation of your right to liberty. Then the police should be held accountable. The police should be held accountable. So that your substantive right to liberty should be enforced. So what procedures should be followed in order to hold that police accountable for violating your right to liberty? Procedural laws talk about that. Procedural laws talk about that. Somebody has stolen your property as you. Your property has been stolen by somebody, and he was caught. Your right to live, your right to property was violated. So that person should be caught and presented before court of law. He has to be presented before a court of law. Justice has to be served because your right to property has been violated by that individual because he has taken your property. So how should your substantive right be enforced? How should that person be tried before a court of law? Then procedures have to be followed. Those procedures are dealt by criminal procedure law. Criminal procedure law. So criminal procedure laws provide mechanisms of enforcing your substantive rights. Your substantive rights. Then it is widely held that there are two approaches of criminal procedure. There are two models of criminal procedure. The due process model and there is a crime control model. The due process model and the crime control model. Mind you, criminal procedure, as I said, is a means of enforcing your substantive rights. Okay? It's a process that helps to enforce justice. It's a process that helps us to serve justice. Okay? It provides procedures on how justice should be served. Okay? Then, generally, there are two models of criminal procedure: due process model and crime control model. Okay? Let's first consider the crime control model. Model helps that the safety and security of the public should be given paramount emphasis. Paramount emphasis should be the safety and security of the public. So the criminal procedure should be crafted taking this objective into consideration. Taking this objective into consideration. So there has to be heavy penalty, or there has to be serious punishment. Serious punishment should be imposed on those who are found guilty of committing an offense. You know, it says this crime control model, the crime control model tells that whenever criminal procedure rules are crafted or organized or established, when criminal procedure rules are established, the prime focus should be the maintenance of safety and security, of peace, stability, safety and security of the public. Our goal should be that we have to control the crime. We have to control the crime so that the safety, security and peace, stability of the society will be maintained. So we have to impose serious punishment on individuals who are found guilty of committing an offense, because we have to control crimes. Crimes shouldn't happen. So that should be our target. That should be our target. That is the crime control model. So there are some states which crafted their criminal procedure bearing this model in mind. There are some states whose criminal procedure rules are influenced by this model. Okay? ስለዚህ crime control model የሚባለው በቃ ፕራይም ታርጌቱ ክራይም ኮንትሮል ማድረግ ነው። ዋናው ዓላማው የክሪሚናል ፕሮሲጀር ህግ ዓላማው ዋና መሆን ያለበት the sole purpose, the primary purpose, okay, the main focus of the criminal procedure should be controlling the crime and keep maintaining the safety and security of the public. So serious punishment should be inflicted on those who are found committing this offense, and we don't have to bother about the rights of the accused person. We don't have to worry about the rights of accused persons. Okay? So our focus should be controlling the crime. That is the crime control model. So there are some states whose criminal procedure rules are influenced by this model. Whereas the second one, the due process model, on the other hand, says that the primary target of the criminal procedure rules shouldn't be controlling the crime. It shouldn't be influenced by controlling of the crime, but the rights of the accused should be taken into account. Its target, of course, is controlling crime, but it also gives emphasis to the rights of accused persons. To the rights of accused persons. We shouldn't be, according to this model, the criminal procedure shouldn't be influenced by the controlling of the crime. It should also give emphasis to the protection of the rights of accused persons. So this due process model gives emphasis to the rights of accused persons. It gives emphasis to the rights of accused persons. So it guarantees rights of accused persons' rights, like the right to privacy, the right to liberty, the right to fair trial, the right to presumption of innocence, and the like. So this model held that the rights of accused persons should be also protected in the criminal proceeding process. Okay? So countries, there are some states that are influenced by the due process model, and there are also states that are influenced by the crime control model. And also there are states that take a balanced approach of these two models. A balanced approach of these two models. Okay? So it is very important. The right approach is the approach that balances these two models. Okay? The criminal procedure target shouldn't be only controlling the crime, but at the same time it should also give protection to the rights of accused persons. Right? So these are the models. Crime control model and due process model. So in order to judge our criminal procedure, whether it is influenced by crime control model or due process model, then it requires critical analysis of the provisions of this criminal procedure. But generally, we can say that our criminal procedure takes a balanced approach, midway between the crime control model and due process model. Because there are some provisions which indicate that the crime control model is given emphasis, and at the same time there are due process guarantees, fair trial rights of accused persons granted in the various laws that are applicable during criminal proceedings. So the midway balanced approach is attempted to be taken in the criminal justice system. And let's see what are the sources of criminal procedure. Criminal procedure of Ethiopia, you will see that we do have criminal procedure code. We do have code. But it is not only this code that talks about criminal procedure. Okay? We do have this criminal procedure code. And there are also other legislations that have provisions on criminal procedure. Okay? So there are legislations There are also sources of the criminal procedure. Like, for example, the Anti-Corruption Proclamation, the Anti-Terrorism Law. They have procedural rules. Okay? So legislations are also sources. Constitution also provides the source of criminal procedure. The federal constitution, if you see, there are a number of procedural guarantees or due process rights, like the right to presumption of innocence, the right to public trial, and the like. These are procedural rights. They are also sources of criminal procedure. And there are also other subsidiary. There are also, in addition to legislations, there are also other subsidiary laws, subsidiary legislations, regulations, and the like, details that deal with specific types of crimes, like the Anti-Corruption Proclamation. There are a number of regulations and detailed laws. Okay. And also the cassation decision, the cassation bench, the Federal Cassation Bench elaborates on some procedural provisions. And as you know, the decision of the Cassation Bench is binding over lower courts. If the Cassation Bench is decided by not less than 5 judges, it says that the decision of the Cassation Bench is binding. Okay, it's binding. So the decision of the Cassation Bench also serves as source of the criminal procedure, because it provides elaborations of criminal procedure provisions. It provides elaborations. Even though it doesn't create new law, it elaborates. So it can also serve as a source. Okay? So, just to clarify at this stage, in Ethiopia, you know that Ethiopia adopted a federal state structure. Federal state structure. Okay? So there is a federal government and there are regional governments or regional states. But we do have one criminal procedure code. So this criminal procedure code is applicable for courts both at the federal and regional state level. So this criminal procedure code, wherever region you are going, whether you are working at the federal level or at the regional level, the applicable criminal procedure law is this one. And also these subsidiary legislations also apply. If it is an anti-corruption case, for example, there is an anti-corruption proclamation, then that anti-corruption proclamation has provisions about criminal procedure rules. Okay? So you don't have to be confused. Even though we adopt federal state structure, insofar as criminal procedure rules are concerned, then the laws are similar. This criminal procedure you apply wherever region you go. So there is no confusion insofar as the application of the criminal procedure is concerned.